The 5th District Court of Appeals in Dallas, Texas is now in session. Justice Peterson presiding.
Thank you. We'll call case number 0519000997 CV, John Doe versus Roman Catholic Diocese of Dallas. Both sides present and ready?
Yes, Your Honor.
Yes, Your Honor. Thank you very much. Okay, well, I assume y'all are familiar with our timing system. The appellant will have 20 minutes, the appellee will have 20 minutes, and the appellant will have 5 minutes for rebuttal. You see the timer on one of the screens, I presume. When it turns yellow, you're running low on time. When it's red, unless you're in a conversation with one of the justices, please finish up as quickly as you might with your final thought. And whenever the appellant is prepared, you may proceed.
All right. Thank you, Your Honor. Good morning, and may it please the court. My name is Lacey Most, and I represent the appellant, John Doe. At issue is whether a sexual misconduct policy, a policy that is in place to prevent and respond to criminal conduct, is shielded from scrutiny if that policy is in place at a religious organization. This case is about the limits of the ecclesiastical abstention doctrine.
Wait a second, is this case about the policy or the diocese implementation of the policy?
The diocese implementation of the policy, Your Honor.
Okay.
John Doe, a sexual abuse survivor, trusted the Dallas Diocese to follow its written procedures for responding to his sexual abuse report. The Dallas Diocese did not follow its procedures, and that failure left John Doe re-victimized. John Doe then filed this fraud claim for the Dallas Diocese failure to follow its written policy. The defendant and appellee, the Roman Catholic Diocese of Dallas, filed a plea to the jurisdiction. The plea did not address the merits of the case, but rather if the court had subject matter jurisdiction. The trial court erred in granting the Dallas Diocese plea to the jurisdiction, and this court should reverse and remand to the trial court for further proceedings. There are limits to the ecclesiastical abstention doctrine that prevent its application to this case. First, the implementation of a sexual misconduct policy involves a compelling government interest. Second, the Dallas Diocese failures in implementing this policy have already compromised that compelling interest, namely appropriate prevention and responsiveness to sexual abuse reports. Three, that policy has been interjected into the public discourse by the Dallas Diocese in representations to the media, its public posting on its website, and in representations to the Dallas Police Department, Detective David Clark. Recent case law indicates that interjecting something like this into the public discourse has implications for the ecclesiastical abstention doctrine.
If I may, sorry, I didn't want to interrupt you. I want to understand you. Are you suggesting that the statements that the diocese and its agents made to Detective Clark was I understood you to say that that was injecting these issues into the public domain in some variety. How is responding to questions of a police investigation injecting it into the public sphere?
I believe it's similar, though not the exact same, as interjecting it or bringing it up in a press conference or to the media, but as a representation to law enforcement, secular authority, about what the Dallas Diocese is doing in response to sexual abuse allegations.
But aren't they really responding to questions from law enforcement? I mean, you're not suggesting that the Dallas Diocese went to the detective, correct?
Correct, Your Honor. So the interjection issue and this public interjection into public discourse issue in this case would be more along the lines of statements made to the media and publicly posted statements on the website. But Your Honor, I believe that the statements made to law enforcement are also relevant because the Dallas Diocese represented to law enforcement, the Dallas Police Department, that these steps that were outlined in the sexual misconduct policy are an investigative procedure for responding to sexual abuse reports, as opposed to saying this is purely a religious matter. This was instead, it was represented as something done to respond to and in response to criminal conduct, Your Honor.
Thank you.
And fourth, this case can be resolved without delving into religious doctrine. Several cases have held that there are limits to the ecclesiastical abstention doctrine. Our federal Fifth Circuit and the Simpson v. Wells Lamont Corporation noted that on rare occasions, there exists a compelling government interest in the regulation of public health, safety, and general welfare, have the courts ventured into the protected area of management of a church or religious organization. Similarly, Your Honor, in the Texas Supreme Court, in the Pleasant Glade Assembly of God v. Schubert, the court noted conduct, even under religious guise, remains subject to regulation for the protection of society. Additionally, the court went further to state that religious practices that threaten the public's health, safety, or general welfare cannot be tolerated as protected religious belief. And Your Honor, additionally, in the Pleasant Glade Assembly of God v. Schubert, in that case, there was a divided court with 3 of the justices dissenting in the Texas Supreme Court. And Chief Justice Jefferson noted in his dissent concern about the expanding application of the ecclesiastical abstention doctrine, which indicates that the courts have concern that this doctrine is becoming too broad, and in Chief Justice Jefferson's words, the risk that a tortfeasor may merely allege a religious motive to deprive Texas courts of jurisdiction. So the ecclesiastical abstention doctrine has limits, and those limits should apply to this case, so that is not applicable, because the government has a compelling interest in protecting children and response from sexual abuse, and protecting vulnerable individuals from sexual abuse, and making sure that this criminal conduct is handled appropriately and in the manner so that these crimes can be properly investigated by secular authorities and prosecuted. Your Honor, there are not the cases which the Dallas Court of Appeals.
Were the allegations against this priest referred to the police, and did the police follow up and pursue that?
They were eventually referred to the police, Your Honor, and the police are investigating at this time.
Okay. All right.
Ms. Most?
Yes.
One of plaintiff's allegations is that following his invocation of this policy, communication from the diocese deteriorated. Do you think is it your position that falls within the pastoral care aspect of the sexual abuse policy or not?
Your Honor, part of the policy discusses staying in communication with the individual reporting the sexual abuse. I believe there may be parts of that which would implicate pastoral care, but this was also in terms of him getting help for the communication also deteriorated in terms of him following up with the application of the policy, such as he followed up to see if this was ever going to be referred to the review board as required by the policy, and was informed by the Dallas Diocese representative that it would not be referred to the review board for determination of if he was abused as a minor or as a vulnerable adult. So, Your Honor, I believe in that instance, that does not fall under a pastoral care concern.
Okay.
Your Honor, the cases that the Dallas Court of Appeals and the Texas Supreme Court have addressed, in general, address cases that are very typically protected by the ecclesiastical abstention doctrine. For example, in Ray Episcopal School of Dallas, this addressed a membership issue with a student's enrollment at a private religious high school. And furthermore, Your Honor, in that case, there was no compelling government interest, and that was not alleged in that case. In Ray Episcopal School of Dallas dealt with a student who was left the school during the day when he was not supposed to use marijuana, and then lied about it, and then he was asked to withdraw from the school. There's no compelling government interest in ensuring that that student is able to attend a private religious school. And and then many of these other cases that have been cited by the appellee address employment disputes and membership. Those are issues that are clearly within the protection of the ecclesiastical abstention doctrine. And in general, they do not address the compelling interest issue. This argument has not been fully addressed by the Court of Appeals.
Counsel, I'm looking at Section 1, General Provisions, Article 1 Policy Statement, and as I read it, there are lots of doctrinal concepts discussed in that policy statement. So it seems to me, and correct me if where I go wrong in this, that Doe made a complaint, the diocese investigated it, took action, but during the process of doing those things, they had to make decisions about how to conduct the investigation, who to contact, whether it was necessary to involve the review board, what to say, and all these decisions had to be made in the context of the policy of behind the policy goals and thoughts behind the policy that we're talking about. So how is this case really not about the decisions made in implementing this policy?
Your Honor, the policy provides some discretion in some steps, but not in all of them. For example, there was no discretion in the policy to submit the complaint to the review board or not, and there was no discretion for the review board to not to participate or not participate in determining whether child sexual abuse or sexual abuse of a vulnerable adult occurred. So that doesn't require going into a doctrinal decision process. That's just simply the review board was not involved in the determination of if sexual abuse of a minor or vulnerable adult occurred.
Didn't the people processing the claim have to balance interest, the diocese interest and Doe's interest and the priest interest in making their decisions?
In some aspects they do, but in terms, the policy does, however, outline concrete steps that are represented to the public and to John Doe on what's going to happen when there is a sexual abuse report. And the compelling interest that the government has in sexual abuse reports and making sure those are handled appropriately comes into play here, because it comes into play because while they have some discretion in what they're going to do, by making these representations of a policy they're going to follow, they're essentially making a representation to the public that we have these in place to make sure, and we're going to follow these steps to make sure that we're doing what we need to keep children safe and to appropriately respond to sexual abuse reports. It gives the public a sense of security and sense of safety, and for that to just be disregarded without ever being subjected to scrutiny makes that promise of safety hollow to the public.
So let's say that the diocese had submitted your client's issues to the review board. There wouldn't be a lawsuit?
Your Honor, if the diocese had submitted it to the review board, in a timely manner as noted in the policy, and if the review board had fulfilled its role as outlined in the policy, then the case would certainly be more difficult, Your Honor.
So aside from referring this matter to law enforcement, would you concede that they did, and removing the priest from association with the Roman Catholic Diocese of Dallas, what other relief could the review board's referral to the review board, what additional relief would you be looking for?
The diocese made a statement to made a public statement that this priest was removed due to serious boundary violations with adults, and we emphasized that it was with adults, and that was not the case here.
Well, that was a correct statement, wasn't it? I mean, one of the allegations is that Doe was abused as an adult after a bachelor party.
Yes. However, the abuse began when John Doe was in high school, including which the diocese had evidence of at that time.
So your view is what if the review board had come to the same conclusion the diocese came to, that perhaps they just didn't believe John Doe?
Your Honor, I still believe that the case could proceed because of the compelling government interest at play. The review board has been represented to the public as a learned body with persons qualified to evaluate and people who understand child sexual abuse. And I believe a case still could have proceeded. However, that it is more clear for this case where the Dallas Diocese didn't follow its outlined policy.
Uh-oh.
Ms. Most, can you hear me okay?
Yes.
I have a question for you. And Article 2 of the policy, sexual abuse has a definition, and it states that the norm to be considered in assessing an allegation of sexual abuse of a minor or vulnerable adult is whether conduct or interaction with a minor or vulnerable adult qualifies as an external, objectively grave violation of the Sixth Commandment. Is it possible to prosecute this lawsuit without an examination of what that means?
Your Honor, yes, it is possible to prosecute this lawsuit without an examination of that, because the policy also relies on secular law in evaluate and defining sexual abuse, sexual harassment, and we can rely on those secular definitions in looking at in prosecuting this lawsuit.
Okay.
Your Honor.
Okay, the policy talks about youth or vulnerable adults, and this is really kind of hyper-technical, but it's an or, which is typically disjunctive. So if they satisfy one of those, have they not satisfied the policy?
I'm sorry, Your Honor, could you repeat the question?
The policy talks about claims involving youth or vulnerable adults. And granted, it's a little technical, but it's or, which is a disjunctive, one or the other. So if they address one of them, have they not complied with the policy?
Your Honor, I believe that they're required to review the entire report and claim. And in this case, there was evidence that John Doe was abused as a minor and as a vulnerable adult. And significantly also, Your Honor, part of the reason his complaint was not timely submitted to the review board, and he was informed that his complaint would not be submitted to the review board, although it ultimately was several months later, was that it was decided he was an adult at the time of the incident, at the time of one of the incidents.
Well, and they removed the priest. The review board didn't need to resolve whether the priest had behaved inappropriately. They had removed the priest, correct?
Yes, Your Honor. He was removed, but Your Honor, I still believe that there is harm in misrepresenting why he was removed, and not in saying that it was only because of inappropriate conduct with adults.
Well,
Did they say only or just that he was removed because of this reason? I don't
Your
think
Honor, I
they said
believe
only.
the statement, I believe, said was removed because this priest was removed because of serious boundary violations with adults. We emphasize that this was boundary violations with adults. By bringing it up twice and saying adults multiple times and then further emphasizing adults, I believe the attempt there is to claim that this is only with adults.
well, he acknowledged that, though. I mean, the priest, there was no dispute that had occurred. Priests aren't supposed to have, sexual relationships. And he had acknowledged that. So there was no debate. I mean, he might have given terrible homilies too, and they didn't mention that. In your view, does that make it a fraud claim? I mean,
yes, Your Honor. Not because complaining about a priest giving terrible homilies in omitting that and explaining why a priest would resign is very different than omitting that this priest was grooming and abusing a minor, and that the diocese had evidence of inappropriate shirtless pictures of this young man in the church rectory, a scrapbook outlining grooming and abuse. To me, that's very different than his conduct as a priest, such as giving homilies.
thank you.
All right. Your Honor.
You're out of time.
Oh,
Well, you're going to get a rebuttal opportunity. Mr. Leatherberry, whenever you're prepared.
Yes, Your Honor. May it please the court. As the Texas Supreme Court recognized in Westbrook and in Pleasant Glade Assembly of God, and as this court recognized in the ESD case and the other cases cited in that case, the First Amendment's free exercise clause was designed to prevent excessive entanglements between the church and the state. Courts use the principle of ecclesiastical abstention to enforce the free exercise clause and to preserve the church autonomy doctrine embodied in that clause. The church autonomy doctrine and the ecclesiastical abstention principle prevent the state from interfering in church governance and decision-making, including but not limited to when those church management decisions reflect religious doctrine and practice. The trial court's order is at tab 1 of the bench book that we filed yesterday. And Judge Evans was exactly right to dismiss plaintiff's sole fraud claim because plaintiff's claim seeks to impose liability on the diocese for allegedly lying about and not complying with its sexual misconduct policy. A policy that
Leatherberry, is the abstention doctrine implicated anytime somebody challenges the application of a policy, an internal policy of the diocese?
It well could be, Your Honor. I think here you have a policy that's grounded in doctrine and also has some civil law aspects of it. But the roots are very doctrinal. I guess the case that comes to mind is Retta versus McConan from the court's docket, which was about construction of church bylaws, where the ecclesiastical abstention doctrine applied. Membership was implicated, but it was a secular requirement of $350 payment to be a member of the church. And your court held that the ecclesiastical abstention doctrine applied to that type of bylaw construction. And it's really a cardinal principle of ecclesiastical abstention that religious bodies have the right to interpret their own policies. And so it well could be, Your Honor. I think it definitely is here.
Do they have the right to ignore their own policies?
Yeah.
Yes, Your Honor, they do, I believe.
So, okay. So in your view,
As far as that goes, absolutely, they cannot comply with their policies.
so you can announce publicly you can tell the whole world, we're going to do A, B, and C and just never do it. And it's just none of our business.
That's an extreme example, Your Honor, but
right.
But I understand where you're going. I think our case is much, much simpler because of the ecclesiastical processes that were at issue and the ecclesiastical principles and processes that the plaintiff's fraud claim would interfere with. Justice Whitehill asked about, is it about the policy or is it about the implementation of the policy? And I really think it's about both. The policy is grounded in Catholic doctrine and in the charter and norms adopted by the United States Conference of Catholic Bishops. Plaintiff would have the court and a civil jury second guess core ecclesiastical and governance issues, such as how the diocese interpreted the ecclesiastical portions of the policy, how the diocese provided support and pastoral care to the plaintiff, how the diocese and its leaders interacted with two other ecclesiastical bodies. That is, the Diocesan Review Board is an ecclesiastical body, and the Congregation of the Faith, of the Doctrine of the Faith in Rome is an ecclesiastical body. And plaintiff would have the court second guess the diocese's decision about how it interacted with those other ecclesiastical bodies. Plaintiff would have the court second guess how the diocese disciplined the accused priest, which is undisputedly very swift action was taken against this priest. And the plaintiff would also challenge how the diocese communicated that discipline to parishioners, to members of the parish where that priest served.
Mr. Leatherberry, I'm
Go
sorry.
ahead.
Do you, does this policy apply to a non-parishioner complaint of sexual abuse by a priest?
Your Honor, if the claim was by a non-parishioner that the diocese committed fraud in not following its policy and investigating that claim brought forward by the parishioner, I'd say yes, the ecclesiastical abstention of doctrine does apply. Because
What about
the court to intrude in those ecclesiastical processes and in the governance decisions that the church has the autonomy to make.
would the church undergo this same process if they were faced with a non-parishioner complaint of sexual abuse?
I believe so, Your Honor, but that's certainly not, there's no evidence one way or the other in the record.
Okay.
But I think these are the policy was meant to handle all complaints brought to the diocese that fall within the scope of the policy.
Okay, thank you.
So,
I have a question.
yes, sir.
Your colleague talked a lot about compelling governmental interest.
Right.
It appears that Doe relies heavily on that. Now, the disclosure talked only about a vulnerable adult. Wouldn't there be a compelling governmental interest in also disclosing that this guy has a past of abusing minors? Wouldn't the government be interested, or the citizens, right, be interested in knowing that, even though he's defrocked and out of the church? Wouldn't
Your Honor,
information have out there?
Your Honor, I think the question delves very deeply into the investigative process that the diocese used, and some of the other members of the court asked about, what if the diocese believed this? What if they believe that? Are you trying to second guess that? So I think it's very important in this case, and in talking about the alleged compelling governmental interest, that this is not an abuse case. This is a fraud case. And although there are allegations of abuse and discipline of a priest for abuse that the diocese found, the same governmental interests are not at stake in this fraud case as they are in a negligence or intentional claim for abuse.
But did the government, the citizens through the government have an interest in knowing that this guy might be a child predator? Apart from this particular claim, just as a matter of general information, that's why we have a sex offender registry.
Well, and that's why the diocese reported these allegations to CPS, and that's why they investigated them, and that's why the police are apparently now involved. And, Your Honor, the court talked about balancing interests, and the diocese made its decisions to act swiftly, to suspend the priest, to cause the priest's resignation. It's not in the record, but laicization is underway for this priest. subsequent to our proceedings last year. And so there are many, many interests to be balanced. And the court would require the diocese to have found things that the diocese apparently didn't find in the course of its speedy investigation. And the court would be regulating what the diocese, how the diocese communicates that ecclesiastical action and how it communicates with its parishioners. So I think
wouldn't the court really just be saying, you've said you're going to present this to the review board publicly, you've said this is the process we're going to follow, just follow your process? I mean, the diocese made the decisions when the diocese formulated the policy, but then the diocese ignored the policy, according to the appellant. So all we'd be saying is the diocese has already weighed all of the doctrinal complications when formulating the policy. Just go follow it.
Your Honor, there's really no just in Your Honor's question. The court would be second guessing the diocese's decision to involve or not involve another ecclesiastical body of the church, the Diocesan Review Board. And that's a quintessential church governance question. The court would be intruding, would be entangling, and would be violating the ecclesiastical abstention doctrine. So that would be a major intrusion into church policy, Your Honor, because these are not specific concrete acts. That's another one of plaintiff's arguments based on a part of the Tilton opinion from the Texas Supreme Court that's not really part of the opinion. It was in the plurality opinion and isn't really binding, but these are not specific concrete acts. This is an investigation that involves judgment and discernment and faith-based decisions every step along the way of the investigation and the process, Your Honor. So it's really not, just you should have told the review board or you should not have told the review board. Same thing with the Congregation of the Doctrine of the Faith. That's an ecclesiastical body that sits in Rome. The bishop exercised his authority to suspend the priest, to secure the priest's resignation, and to communicate about that discipline. And those are all quintessentially ecclesiastical processes. Here,
For point of clarification, the review board was ultimately involved. It's just a question of it was that time point. Is that correct?
That's right, Your Honor. Ms. Edlin testified at paragraph 25 of her affidavit that the review board was involved and evaluated the pastoral care and actions of the diocese.
So at that point in time, could the diocese have taken different action, disclosed more, disclosed less? Well, I guess once it's disclosed, you can't disclose less. But had the review board thought it was necessary, they could have said, no, we need to say more. Is that?
I suppose that's certainly possible, Your Honor. The bishop, in consultation with the diocesan review board and the bishop. I want to talk a little bit, if the court will, about. I think I've said enough about plaintiff's allegations and how they intrude into the ecclesiastical processes that are involved. Plaintiff challenges how the diocese responded pastorally to him, how the diocese disciplined the priest, how the diocese involved or did not involve two other ecclesiastical bodies, and how the diocese communicated with parishioners about the disciplinary action taken towards the priest. So in substance and effect, and that's the analytical test that the Texas Supreme Court in Westbrook and this court in numerous cases has employed, what is the substance and effect of the plaintiff's fraud claim? And just talking about the processes challenged by the plaintiff emphasizes that the relief sought by the plaintiff intrudes deeply into church governance, into several steps of church governance, and into core ecclesiastical functions such as discipline of priests. The plaintiff argued that these cases, the ecclesiastical abstention doctrine is really limited to membership or employment cases. That's just not part of the substance and effect test that this court must employ. A lot of the law certainly was made in membership and employment cases, but the test remains the same no matter what the emblemata of the claim, no matter what the elements of the claim, and no matter what the claim would have the court do or a civil jury do. Briefly, I want to say too that there's an argument that neutral principles of law should apply. And that's one of the analytical errors that the Amarillo court made in the Diocese of Lubbock case. We referred the court to the state's amicus brief in the Diocese of Lubbock case, and the state makes the argument, probably better than we did, that the Texas Supreme Court has never applied neutral principles outside of a property case, outside of a church property case. And really, that's what Justice O'Neill's opinion in Westbrook indicates as well. And here, plaintiff has not really tried to define his claim in civil law terms. He invokes the religious language in the policy and the religious principles in the policy in order to make this fraud claim.
Mr. Leatherberry?
Yes, Your Honor.
I'm curious whether you know of any instance where any diocese has used this policy defensively in a civil lawsuit, asserting negligence. In other words, the diocese has responded to allegations by saying they couldn't have done anything about it because the plaintiff didn't follow the policy.
I'm not aware of any case like that, Your Honor. My representation of the diocese is not extensive, so but we were not able to find any case like that when we were following up on the plaintiff's citation of the out-of-state cases for the presence of a compelling governmental interest in preventing sexual abuse. So
Okay.
we did look, as the court knows, the situation in the Diocese of Lubbock case and a similar case pending in Corpus Christi is a very different situation where defamation claims are being alleged because particular clergy were listed on the list of credibly accused priests. So certainly it was not used as any kind of shield in an abuse case that I know about.
Okay, thank you.
Yes, Your Honor. Let me speak just a little bit more about the Diocese of Lubbock case. There, the court applied neutral principles and held that because statements were made outside of the confines of the church, that ecclesiastical abstention did not apply. This is really an illogical holding. It makes no sense to limit the church's free exercise to statements made only to church members. Here, there's no alleged communication specific to plaintiff's claim that went outside the confines of the church, except for the posting of the policy on the diocesan website. There's no alleged actionable communication made except to plaintiff and parishioners and in connection with the investigation of the plaintiff's report. Plaintiff points mostly to general after-the-fact statements in Detective Clark's affidavit, for example, in a press conference by Bishop Burns, generally about the problem of sexual abuse in the church. But these are not, it makes no sense to use those statements that have nothing to do with plaintiff's claim here, and it would make no sense to make those statements actionable statements. As the court knows, the Diocese of Lubbock case is pending before the Texas Supreme Court. Briefing on the merits was recently concluded. There were a ton of amicus briefs filed, including the one by the state that we brought to the court's attention specifically. And we submit that the state makes really compelling arguments that the free exercise clause, the original understanding of the free exercise clause and the unworkable standard that the Amarillo court applied should be reversed. The case should be reversed. Ecclesiastical issues should not be equated with private issues or secret issues or non-public issues. To the contrary, we cited to the court the Milivojevic case from the U.S. Supreme Court and In re Goodwin, which I believe came from San Antonio, where the church autonomy doctrine was not compromised, even though there had been public discussions of the issues involved. It would be strange for the free exercise clause not to protect public speech on ecclesiastical and governance issues. After all, the Catholic Church and virtually all other religious denominations are charged with ministering to and spreading the faith to those who are not already members. So public discussions of sexual abuse as an issue for the church should not be a reason to limit the application of the ecclesiastical abstention doctrine in this case. There were some procedural and evidentiary issues, Your Honors. We covered those pretty thoroughly in our briefs. We believe Judge Evans properly considered Bishop Kelly and Ms. Edlin's affidavits. We believe that Detective Clark's affidavit should not have been admitted, but it's immaterial and shouldn't change the court's ability to affirm the judgment below. It contains no statements about the plaintiff or about this investigation. Was made several years after the fact. And I see my time's up. I'm happy to answer any more questions.
Any questions?
I don't.
Thank you so much, Mr. Ledbury.
Thank you, Your Honors.
Ms. Most, whenever you're prepared.
Yes, Your Honor. Detective Clark's affidavit is relevant because it discusses the investigative policy that's outlined in the sexual misconduct policy at issue in this case. Detective Clark qualifies as an expert witness and can opine on this and discuss the problems and compelling interests that he has seen compromised through misapplication of this policy. Your Honor,
the affidavit contain any information that relates directly to your client?
It does not, Your Honor, but it raises a genuine issue of material fact as to the how this problems with how the policy has been implemented. And Your Honor, because it raises a genuine issue of material fact, the court erred in granting the plea to the jurisdiction instead of allowing these factual issues to further develop.
What fact?
I'm sorry?
Please identify the factual issues that you need to further develop. That wasn't clear to me, my inexpert reading of your briefing. Tell me what those fact issues are.
Your Honor, it goes to, in particular, the compelling interest position that this policy implicates a compelling interest that would justify the court exercising jurisdiction in this case. Your Honor, the police are in the process of investigating John Doe's claim, but this hearing, the trial court's ruling was rendered early in that process. Detective Clark's affidavit was only made available to the public a little more than a week before this ruling occurred. And John Doe's, the investigation into John Doe's claims is ongoing.
Are you saying that the diocese actions in this case prevented the prosecutors from subpoenaing anybody to the grand jury to investigate this claim?
No, Your Honor, just that John Doe's claims were in the early stages of investigation at the time the court entered its ruling.
Has the policy or the implementation prevented Detective Clark from seeking to interview any potential witness in this case?
Not into this case. However, Detective Clark's affidavit goes into the problem, how implementation of this policy hindered hindered his investigation, resulting in him needing to request a search warrant in the criminal investigation into other matters. Your Honor, I believe the heart of this case is that there's a risk to safety and general welfare and to the public if religious organizations are permitted to promise that they will implement safeguards and policies to protect and respond to sexual abuse of minors and vulnerable individuals, and then never be held to scrutiny in the event that those policies are not implemented. By making those representations, parents and others trust that there is a system in place to keep people safe. In the position,
Ms. Mose,
yes.
I have a two-part question. Going back to what we talked about earlier about the definition of sexual abuse within the policy, do you concede that this lawsuit requires an examination of whether your client experienced sexual abuse? And if so, do you concede that making that determination will require an examination of whether Hines' conduct violated the Sixth Commandment?
Your Honor, it does require, to some extent, investigation of whether plaintiff made an allegation of sexual abuse of a minor or vulnerable adult. But to determine if that happened, we're not required to go into church doctrine to determine if a minor or vulnerable adult was abused. Rather, we can rely on the policies references to Texas law, federal law, and child abuse reporting guidelines. So we don't need to go into the theological or doctrinal discussions to make that determination, Your Honor.
Okay.
Your Honor, this case involves a compelling government interest. That compelling government interest has been compromised, and this policy at issue has been interjected into public discourse. For that reason, for these reasons, we ask that the court reverse the trial court and remand to trial court for further proceedings. Thank you.
Thank you very much. We really appreciate the parties' very capable briefing and excellent argument, helping us make the right decision in the case. And the case is submitted. Thank you.
Thank you.